the Law GA channel and welcome to our special content on constitutional law principles. This is our third tutorial lesson on constitutional law, and today we are presenting to you the principles governing citizenship under constitutional law in Ghana. We believe that this lesson will substantially aid in your studies of the law of citizenship, and we encourage you to read the facts of the cases we are presenting to further help you appreciate the principles stated in these lessons. Kindly subscribe to this channel, like our videos, and help us share this channel to everyone. We are grateful in advance. First and foremost, it is worth noticing that there are two basic principles which inform nationality laws around the world. These are your place of birth, lex solis, and your blood descent, lex sanguinis. In Ghana, we recognize both principles. To be a Ghanaian, you must either be 1. A Ghanaian by birth, for the see clause 1 and 2 of Article 6 of the Constitution 1992 and sections 3 to 7 of the Citizenship Act 2000, Act 591. You can also be a Ghanaian by naturalization, and for this you can see section 13 and 14 of the Citizenship Act. Also, there are Ghanaians by registration, and for this you can see Article 79 of the Constitution 1992 and sections 10 to 12 of the Citizenship Act. It is necessary to also highlight that a person could be deemed a citizen of Ghana by birth through foundlings, provided that that person is not above 7 years of age and their parents are unknown. See Clause 3 of Article 6 of the Constitution 1992 and Section 8 of the Citizenship Act for this. Lastly, a person could also become a citizen of Ghana by way of adoption. This is provided that person is not more than 16 years of age and neither of whose parents is a citizen of Ghana and who is adopted by a citizen of Ghana. Please see Clause 4 of Article 6 of the Constitution 1992 and Section 9 of the Citizenship Act for this. We shall subsequently attend to dual citizenship and allegiance. But for now, let us commence by looking at what the cases are saying about citizenship in Ghana. The first case we'll be looking at is the case of Shalabi and another and the Attorney General, Perez Benjamin J., as he then was. By the proclamation 1996, the National Liberation Council was established to provide for the proper administration of the country. And this did not include depriving Ghanaians of their basic right, citizenship. Citizenship, once conferred, can only be lost by processes specifically stated in the instruments conferring that citizenship, and not by an ambiguity. His Lordship further quoted a dissenting opinion of Warren CJ in the case of Perez and Brownell, 356 U.S. 44, 1958, that citizenship is man's basic right, but it is nothing less than the right to have rights. Remove this priceless possession and there remains a stateless person, disgraced and degraded in the eyes of his countrymen. He has no lawful claim to protection from any nation, and no nation may assert rights on his behalf. His very existence is the sufferance of the state, within whose borders he happens to be in. In this country, the expatriate would presumably enjoy at most only the limited rights and privileges of aliens. And like the alien, he might even be subject to deportation and thereby deprived of the right to assert any rights. This government was not entrusted with power to decree this fate. The people who created this government endowed it with broad powers. They created a sovereign state with power to function as a sovereignty. But the citizens themselves are sovereign, and their citizenship is not subject to the general powers of their government. Whatever may be the scope of its powers to regulate the conduct and affairs of all persons within its jurisdiction, a government of the people cannot take away their citizenship simply because one branch of that government can be said to have a conceivably rational basis for wanting to do so. The second case we'll be looking at is Captain and Minister of Interior, and this will be Per Akufo-Addo CJ. An independent sovereign state has the power inherent in sovereignty to decide what foreign nationals to admit in its community, what conditions to impose on such admission, and to expel at any time any alien admitted into residence. A state cannot be held to have divested itself of any part of its inherent sovereign powers, save by express provisions to that effect. And where such provisions exist, the courts of the state will be bound to give effect to them. The third case is the case of Bruce and Attorney General, Per Adumwa Bosman J. The rule that registers of baptism are evidence of dates and place of baptism, but not of dates or place of birth, may be strictly applicable in England, where provision was made from early times for the registration of births of children. It should obviously not be applied too strictly in a country in which everything, the native law itself included, depends on oral tradition. Now, the next thing we'll be looking at is loss of citizenship. A citizen of Ghana can lose his citizenship in of two ways, namely, first, through renunciation. Here, paragraph 1 of section 17 of Act 591 states that if a citizen of age and capacity who is also a citizen of another country makes a declaration of renunciation of citizenship of Ghana, the minister responsible for the interior shall cause the declaration to be registered, and on the registration, that person will cease to be a citizen of Ghana. By subsection 2, where the law of a country requires a person who marries a citizen of that country to renounce the citizenship of that person's old country by virtue of that marriage, a citizen of Ghana who is deprived of citizenship of Ghana by virtue of that marriage shall, on the dissolution of that marriage, become a citizen of Ghana. See clause 4 of Article 8 of the Constitution 1992 for this. The second way is through involuntary loss of deprivation or forfeiture of citizenship. Here, section 18 of Act 591 states that the High Court may, on an application by the Attorney General for the purpose, deprive a person who is a citizen otherwise than by birth or adoption of that citizenship on the ground. A, that the activities of that person are inimical to the security of the state or prejudicial to the public morality or the public interest. Or B, that the citizenship was acquired by fraud, misrepresentation, or any other improper or irregular practice. As we bring this second lesson to an end and subsequently bring the fourth lesson, which will be on dual citizenship, let us highlight what Atuguba JSC, as he then was, said in Professor Stephen Kweku Asare and Attorney General 2012 Supreme Court of Ghana Law Reports. By paragraphs 374 to 381 of the reports of the Committee of Experts, Constitution, on proposals for a draft Constitution of Ghana at 175 to 176, our law provides, among others, that if a citizenship of full age voluntarily swears allegiance to another country and becomes a citizen of that country, then he loses his Ghanaian citizenship. And as the Akufo-Addo report, 1968, for the 1969 Constitution stated, we do not want an occasion where allegiance to Ghana is shared with allegiance to another country. Citizenship is a matter of state sovereignty and has a unique and intricate character which has been specially dealt with in Chapter 3 of the Constitution 1992. And therefore, the verba generalia of the fundamental human rights provisions of Chapter 5 have to be applied with caution in relation to the specialibus of Chapter 3. Consequently, there are varieties of citizenship with varying rights in Chapter 3 itself. This position by Atuguba JSC was reaffirmed by the Supreme Court in the case of Michael Ankuman Nimfa and James Jache-Kwesen. Therefore, in our fourth tutorial session, we shall bring to you the detailed position of the law on dual citizenship and allegiance using 3 cases of the Supreme Court of Ghana. Thank you all for watching. Kindly subscribe, turn on your post notifications, like and share to all and sundry as we will continue to present you more educative and informative content. Thank you.